Hello, welcome to Laex. In our science and technology series, we have discussed few topics already, like cybersecurity, nuclear technology, etc. In this video, we are going to discuss about intellectual property rights. What are these intellectual property rights? What are these types of intellectual property rights? What are the measures taken by the government to promote intellectual property rights? On these issues, we are going to focus on. Let us understand what is the meaning of intellectual property, and then we will move on to the meaning for intellectual property rights. Here, intellectual property means creations of mind, such as inventions, or literary and artistic works, such as books, music, etc., or designs, such as industrial designs, let's say mobile phone has such a certain design, or car has a certain design, or symbols or names or images that are used in commerce. So, intellectual property refers to creations of mind, literary artistic works, designs, symbols, names, and images used in commerce. In general, intellectual property rights have two characteristics. First one, it should have commercial value. It should have commercial value. Second one, it should be harmless. Let's say there is an invention that harms people. Do we consider that as an intellectual property? No. So those inventions, those creations or designs or symbols that are harmless and that have commercial value, they are considered as intellectual property. Okay, now why should they be given legality? Intellectual property rights says that we should give them legal protection. Why? Let's understand here. IP is protected by law. Why IP should be protected by law? Patents, copyrights, trademarks, all these are examples for IPs. Why should they be protected by law? It is because they have invested so much, either their time or money or other resources to go for these particular inventions or artistic works. They should have certain benefit, yes or no? If they have benefit, they will invest further. Otherwise, they invented something, others are using it, they have spent their time, money, everything, but there's no benefit for them. Will they be interested, or will others be interested to invest in such things? No. So, if they get the benefit, there is a chance that the environment for innovation and creativity can flourish. That's why, to give the benefit, these are protected by law. They provide the recognition and financial benefit. These are guaranteed by the law. Now let's see what are the types of IPRs. In general, there are majorly 6 types of IPRs. Let us understand one by one. First one is copyright. Copyright is a legal term that describes what? That describes the literary and artistic works. These works cover books, music, paintings, sculpture, film, computer programs, databases, advertisements, maps, technical drawings. All these come under copyrights. Let's say a software comes under what? Copyright. Movie comes under copyright. So, copyright is a legal term. Copyrights are given by law that protects whom? The creators of literary and or artistic works. These are examples for copyrights. Next intellectual property right is patent. Patent is very important commercial legal right. So what is this? Wright brothers, when they designed aeroplane, that's the model for this. Okay, first patent. Patent is an exclusive right granted for an invention, and patent owner has the exclusive right who can use it, how they can use it, all that. So patents, if I have a patent, let's say on a drug, so I will decide the price of the drug. Or if I want others to develop the drug or manufacture the drug using my technology, my invention, I ask them some money. That's how patents work. The other important IPR is trademark. Trademark is a symbol, is just a sign that distinguishes the goods and services of one company to other company. For example, Nike has this symbol, Apple has its own symbol. These are all called trademarks. The other important IPR is industrial design. Industrial design constitutes ornamental or aesthetic aspect of an article. Let's say color, or let's say a particular design, three-dimensional feature or whatever shape or surface of an article. So the patterns, colors, lines, these are granted IPR under industrial designs. Next one is geographical indication. This is frequently seen in newspapers. Geographical indication tag is given to that, this, like that. So, geographical indication consists of what? There is a certain geographical area. From that geographical area, let's say there is a good originated from that area which has specific features that are found only in this particular geographical region. Then that particular good is given a specific symbol or name with that particular location. So location based speciality. Most commonly, geographical indications include name of the place of the origin of good. So origin of good is considered to give this IPR. The final one is trade secret. Trade secrets are also IP rights. Let's say confidential information. For example, KFC recipe or Coca-Cola recipe. Do we know that? Do we know the recipe? No, because these are considered trade secrets. The unauthorized acquisition of such information will be violating of the trade secrets. So trade secret is also one of the important IPRs. Now let's see the specifics of these particular intellectual property rights. First one is patent. What is the meaning of patent? We just understood. Patent is an exclusive right granted for invention. What is the Indian Act that deals with patents? Indian Patent Act 1970. What is the maximum time for which this legal right is given? 20 years. That means if a patent is granted to a particular company or a person for 20 years, that particular company or person has the exclusive legal right over it. Then is it transferable? Can the patent holder transfer the technology or invention to others? Yes, they can transfer it, but others should pay some money for them. Royalty. Royalty is fixed by the patent holder. Is it renewable? Can we renew it again? To renew it again, they should go for substantive innovation. A substantive change in the invention should be there, then only patent can be renewed. Otherwise, no renewable. It's not renewable. Next, industrial design. What is the meaning of industrial design? For a particular device or a good, the ornamental or aesthetic aspect of life or that particular good is considered as industrial design. We have Industrial Design Act to deal with this particular patent. It is granted for 10 years. Is it transferable? No, it is not transferable. Can they renew it? Yes, they can renew it by paying certain fees. Then third one is trademark. Trademark is a kind of sign capable of distinguishing the goods and services of one company, that is one enterprise, to other enterprise. This is dealt under Indian Trademarks Act 1999. 10 years is the lifetime. Can they transfer them? No. Can they renew it? Yes, by paying the fees. What is GI? Geographical indication. Goods of specific origin with unique qualities. Here remember, services are not part of it. So geographical indication is given. GI registration of goods act is there. It is given for 10 years. Can they transfer it? No. It is specific to the location. They cannot transfer it. Can they renew it? Yes. What is the condition? They should prove that the specialty still continues. Then the final one is copyright. Copyright is rights of creators over the literary or artistic works. This is dealt under Indian Copyrights Act 1956. What is the maximum time? Lifetime. Let's say a person wrote a book for his entire lifetime and after his death 60 years the rights are given. If someone wants to use it, yes, they can use it, but they need to pay some money, royalty. Can they renew it? No, they cannot renew it. This is a comprehensive picture on IPRs in India. Okay, we understood types of IPRs. Who gives these legal rights? What is the institutional structure in India? Let's understand it. Let's say a company or an individual wants to file a patent. For patent, they goes for this Office of Controller General of Patents, Designs and Trademarks. Or if a company wants to go for copyright, then they go for Registrar of Copyrights. Or a particular person or a company wants to file GI, then they go for Registrar of Geographical Indications. These are three specific organizations under Ministry of Commerce and Industry. Under that ministry, we have a department called Department of Promotion of Industry and Internal Trade. Under DPIIT, we have all these offices. They go and file. They go and file a patent or a trademark or an industrial secret. Yes, they go and they file. They have certain procedure to give them. There are certain laws to deal with these IPRs in India. Based on those laws, they accord the IPR. Let's say they said your application cannot be processed because there is this problem, something like that. Then the companies or individuals, they didn't get satisfied with the answer of these organizations who provide IPR. Then where can they move? They can move to an appellate body called Intellectual Property Appellate Board. Earlier we have Copyrights Appellate Board. Now we merged all of them and we have only one unified appellate board called Intellectual Property Appellate Board. This takes the final decision. This gives the final decision with regards to IPRs in India. They go and file. If they reject or if these companies are not satisfied, they can appeal to this particular board called Intellectual Property Rights Appellate Board. This is the broad institutional structure for IPRs in India. We said Ministry of Commerce and Industry is the nodal agency in India. Yes or no? Then with whom this Ministry of Commerce and Industry coordinates at the international level? We have two important international institutions that deal with IPRs. The first one is WIPO, World Intellectual Property Rights Organization. World Intellectual Property Rights Organization. This in general deals with the IPRs in India, defines the rules. There are certain conventions under WIPO. These are all dealt under this international organization called WIPO, and India is part of it. India is a member of WIPO. Then the other set of institutions with regard to IPRs is WTO, World Trade Organization. Under that we have a separate convention called TRIPS. TRIPS means Trade Related Intellectual Property Rights. These trade related intellectual property rights deal with how to trade and protect the IPRs between the countries or among the WTO countries. WTO is the largest trade organization in the world. WTO, World Trade Organization. Is India a member in this? Yes, India is part of WTO and TRIPS. So India has enacted laws, formulated rules based on the WIPO guidelines as well as WTO guidelines. We understood types of IPRs, certain issues of IPRs, laws that deal with IPRs in India, etc. Now let's understand the importance of IPRs in India. Why IPRs are important not just for India, for any country, why IPRs are important? To promote innovation, to foster innovation and knowledge in any country, we need IPRs. Yes or no? To promote innovation and creativity, we need IPRs in any country, including in India. That's why IPR protection is important. Next, economies are more and more dependent, especially in the globalized world. Economies are more and more dependent. Those who want to invest, they see for stricter laws, especially with regard to IPR. Because if they want to develop some product, if they have protection, then only they come and invest. So for investments, we need IPRs. To achieve certain social goals, let's say we want a particular drug, which should be made affordable. Then social innovations happen when we have protections like these. So for social innovations and social welfare, we need stricter IPRs. Yes, important. Then what the government is doing? Do we have enough number of provisions to promote IPRs in India? Let's see. These are the initiatives taken by the government to promote IPRs in India? I have listed down 20. We can remember, let's say, 10 important measures taken by the government of India to promote IPRs. First one is National Intellectual Property Rights Policy 2016. This policy is to promote IPRs in India, commercialize the IPRs in India, increase the awareness over IPRs in India. Second one, strengthening the institutional mechanisms. There is this particular cell appointed under DPIIT, Cell for IPR Promotion and Management, CIPAM is the name of it. And we have Intellectual Property Rights Appellate Body. We just said that it is an uniform appellate body, and DPIIT oversees the entire institutions with regard to IPRs. This is the separate cell under DPIIT. And we have clearing backlogs and reducing pendency. For this, government has simplified the procedures under DPIIT. They have set up CIPAM to oversee all that. Increase in filings with CSIR, with the DRDO, etc. They started having separate IPR cells so as to increase the filings. Next one is BPR, Business Process Reengineering. Under that, the government has amended the copyright rules, trademark rules. Why? They are to simplify the procedure, simplify in filing the trademark, simplification in filing copyright rules. Next, augmentation of human resources, especially in Indian patents. In filing Indian patents, we had a dearth of human resources. So we augmented the human resources heavily from 2013. Next, creating IPR awareness in starting from the school level to the research level. Creating IPR awareness has been part of many policies and many programs of India. Next, IPRs in school syllabus, CBSE, etc. They have adopted IPRs as part of the school syllabus. IPR enforcement toolkit. See, for example, there is a violation of IPR. Someone went and filed a petition with the police station. They should be ready. So they are trained and then they are given IPR enforcement toolkit. Yes, these are the copyrights already filed. These are the IPR rights already filed. These are the patents already filed. This is on this name. This person has violated. So then they have clear information on who is the owner of a patent or owner of this particular book, etc. They can enforce it easily. So enforcement kit is prepared, police training is been done. Sensitization programs for judiciary. There are many delays and judiciary don't have the specific knowledge on these IPRs. So sensitization of IPR issues has been done under this program. Combating online piracy, especially for copyrights, combating online piracy, for that closing down certain websites, etc. was done. Next, technology and innovation support centers. These are established in each state. Technology and innovation centers are established in each state to promote innovations. Next, Madrid Protocol. This is important. Madrid Protocol is under WIPO. We have this institution called WIPO, World Intellectual Property Organization. Under this, if we file a patent in one country, in general, we need to file it in every country. Let's say there is an MNC which needs to file patent in every country. That becomes burdensome. It consumes a lot of time, it consumes a lot of money. Instead, under Madrid Protocol, through WIPA, what the countries are doing, we are going for global patenting. If once we go and patent under Madrid Protocol with WIPO, that patent is applicable in other countries also. That is Madrid Protocol, and we have become part of it in 2013. And this one, Global Innovation Index. WIPO releases Global Innovation Index every year for 129 countries. We got 52nd rank earlier, 2018. Our rank was 57. Earlier 72, like that. We improved upon Global Innovation Index. We are working on it. And then promotion of geographical indications. We are giving specific tags. We are providing marketing facilities, etc. for GI products. That way we are promoting the enforcement of GI. Social media campaigns. This one is very, very important. IPRs for startups and MSMEs. IPRs for startups and MSMEs is being taken up in 2016. Under this, let's say to file a patent it costs 1000 rupees. For startups and MSMEs, it is done at 80% lesser cost. That means they need to pay only 200 rupees. So that one, and then speedy approval for the patents for the MSMEs and startups, that's been taken up. And then dynamic utility website. What is this dynamic utility facilities? There is a website. Under this website, what are the patents already filed? What are the deferred patents? Deferred means which are not taken up. What are the patents whose time is over? All the details will be mentioned. So the patent filing people can know that, okay, these are the things where we can go and patent, etc. Next, UGC has mandated that in all higher educational institutions, IPR cells should be there. Any innovation should be registered with this IPR cells. These are the important initiatives taken by the Government of India to promote IPRs. This is very important for mains. Very, very important. This is about this chapter called IPR issues in India. If you have any questions, doubts, queries, please let us know in the comment section. All the very best. Stay focused. All the best.